In the Center for the Study of Public Domain's Information Ecology Lecture series. The goal of the lecture series is to invite people from around the university, from the universities in the neighboring area, and indeed from around the country, to come and discuss ideas that relate to information policy conceived at its broadest, ranging from privacy to the patenting of genes, to innovation economics, to the discussion of copyright on the internet. It's an extremely broad range of topics, and we hope that by bringing together people from different disciplines and from different universities, that we will be able to have the richness that the discussion requires. Just a brief announcement, you should have a lecture series schedule up there. I'd like to thank Jennifer Jenkins, who's organized the hard work of organizing all of this. Next week, we're going to have Stuart Benjamin talking about a fascinating issue: should the spectrum, the electromagnetic spectrum, be dealt with through private property? Should we basically chop it up and sell it off in little units, each going to people who want to use it, or should it be some form of commons? We also have coming up Mark Rotenberg, who's the Executive Director of the Electronic Privacy and Information Center, talking about privacy. We have Wes Cohen from Fuqua talking about patents and some of his really fascinating research on the actual effects of patents, both here and in Japan. And finally, we have William Fisher from Harvard, who actually you may have seen some of his proposals discussed recently in the New York Times, who thinks he has a cure for the downloading wars by basically abolishing online copyright and replacing it by flat fees charged to users of computer equipment and then paid out to record companies based on the number of times that different songs are downloaded. So the range of discussion is extraordinarily broad, and that's just this semester. So I'm delighted that you've joined us, and I hope that you will come back in the future and tell your friends. So what I'm going to talk about tonight is the economic irrationality of copyright rules on the internet as currently set up, and to talk about a couple of possible solutions for that, one in particular, Creative Commons. But first I want to mention some of my background assumptions about method. One of the ideas of this interdisciplinary series is to have us try and articulate the various methodologies that we apply, because people coming from different disciplines start out with very different goals: what counts as a proper object of study, what counts as a way of actually dealing with it, and what counts as a solution. Ideally, I'm looking for a method that helps us understand the consequences of intellectual property, that suggests possible reforms in the intellectual property system, that deals with the various ways we encourage creativity, many of which indeed have nothing to do with property rules. Now, to do that, you have to understand the economics of innovation, the economics of production of various kinds of expression or innovation, both online and off. But ideally, it seems to me, and this is the sort of third condition for the method, we can't just look at the various types of incentives that are set up to produce the objects of intellectual property, to produce a new song or to produce a patented drug. We also need to look, and we can borrow from our colleagues, the political scientists and the public choice theorists here, the incentives that are set up in the making of IP policy itself. That is to say, not the incentives to make the song, but the incentives to make the Copyright Act. What are the incentives there? Because if you're going to propose some new set of rules or some new way of dealing with intellectual property, while it's certainly worthwhile for a scholar simply to say, here is the best possible system, regardless of whether it has any political feasibility whatsoever, it would be ideally useful to actually propose reforms which would not only be good, but which might actually have some chance of succeeding. And to do that, you really need to understand something about the economics of the construction of intellectual property policy making, the way that we make our rules on these subjects. The fourth criterion, it seems to me, for a method is we have to go beyond the merely economic. A lot of what we're dealing here with is a set of incentives and the way in which those incentives are structured. But to quote Judge Richard Posner, himself one of the most foremost advocates of the economic analysis of law, economics is a thin and unsatisfying epistemology through which to understand the world. I'm quoting it, I think, in a broader context than he would want it used, but I think it's a valid conclusion. We need to understand also the social construction of reality. We're dealing here with meaning and with meaning making, and one cannot deal with those things merely by saying, what are the costs, what are the benefits? One has to understand the structure of what Terry Fisher has called semiotic democracy. One has to understand the importance of the architectures of our communication system, one has to understand values which may not be purely reducible to economic form, the values we put on free speech that have nothing to do with efficiency. By the way, late arrivals, come on down. There are plenty of seats down at the front. Please come join us. And finally, it seems to me that a proper method needs to avoid an unduly limited conception of the role of a scholar. The typical role for a number of scholars involved in the policy world is to address yourself to a set of fantasy state decision makers. They're fantasy in the sense that the first fantasy is that they're listening to you, right? This is almost always a fantasy, and for many liberal legal scholars has particularly been a fantasy when they address themselves to the Supreme Court. Many of my colleagues are clearly addressing a shadowy Supreme Court, which continued around 1972 along a trajectory which the current Supreme Court has long since departed. They continue addressing the fantasy court in blithe disregard of where the current one is. I find that somewhat unsatisfying. But more broadly speaking, we need to think about the ideas of proposals and policies which are not addressed to the custodians of state power at all, which actually are proposals for different kinds of change, addressed to private groups, addressed to possible changes in civil society. So broadly speaking, those are the goals, the methods that or the ideas that structure my method. So let me turn to one of the themes that I mentioned and very briefly summarize for you what I take to be the conditions under which intellectual property policy is made. One of my colleagues was describing her, this is Jessica Littman, a wonderful scholar, was describing her basically 100-year-long scrutiny of the history of the making of copyright in the United States to a colleague who was a political scientist. He clasped his hands together and said, "Why, that's the most perfect example of industry capture I've ever seen." He was really delighted. This was a system in which the regulators really felt that the way that one actually made regulation was to ask the industries who were to be regulated to literally design a set of rules and then to pass it as it were a contract. And the contract was understood to be between various industries involved in the production of and distribution of expression. To be sure, they had differing interests. The publishers might have marginally different interests from the broadcasters, who might in turn have different interests from the filmmakers. The cable TV companies might have different interests in all of them. But that was those were the people among whom and between whom the contract should be made. Our colleagues in political science tell us that we have problems in policy making where you have the following conditions. You have an extremely concentrated set of forces on one side of the spectrum who have well-identified interests, who are repeat players, who know very well what their interests are, who can predict them well in the future, who are highly organized, who have low costs of organization, who are extremely well-advised. And on the other side of the scale, you have a large group of disorganized, unorganized consumers whose interests may be large in aggregate, but on individual level are relatively small, and whose coordination costs are extremely high and may simply not know what the hell is going on, or indeed what it means even if they did. That in general is a problem for policy making, and it's a problem which beautifully describes the condition in intellectual property policy. In addition, this is, I think, an important addition which the more cynical accounts of this fail to grasp. Many very responsible public servants and legislators genuinely believed that the appropriate role of intellectual property policy was writing a good contract among the affected industries. That wasn't something that they thought was a cynical, backhanded deal. That was their job, right? It's not a matter of, oh, well, this is the best we can do, or even, oh, well, this is what they paid me under the table to do. It was, oh, well, this is what I should be doing. And that problem, I think, is an important one. Given those conditions for the making of intellectual property policy in the public sphere, it seems to me that we start with a set of very important assumptions about what any proposals for reform should do in their turn. First of all, we need to have limited optimism in the short term for immediate major changes in the legislative arena. We could propose all kinds of wonderful things here and now, and I'd be happy to do so in terms of changing the law of copyright in order to make it more rational. But the idea that that's simply going to be carried into force, I think, is of a very low probability. Second, anything that we put forward should be a proposal which deals both with the perceptions that the public has of the system and of the system itself. In other words, anything that you describe has to be something which has simultaneously to address some concrete problem and also perhaps operate as some kind of sign or symbol to the general public about, yeah, this is why I should care about this system and this is how it could be different. Each thing has to be both something that works, in other words, but also some kind of icon, some kind of image of a larger perspective. It needs to suggest a broader frame of reference as well as working on a pragmatic, limited problem. And finally, we need to suggest private workarounds, things that can be done by citizens and by groups without necessarily turning to Congress or the courts, as well as proposing public solutions. Okay, so those are the conditions under which we labor, and as I've already said, the methods that we should apply, now the payoff. Much of contemporary intellectual property scholarship, and I confess I have produced a fair amount of it myself, that focuses on intellectual property online, is really concentrating on a single question, which is the losses that intellectual property is perceived to be suffering online, from downloading, massive piracy online, from the leakiness of the internet, from the fact that perfect digital copies can circulate so easily with let or hindrance. And indeed, this is a genuine issue. It is, in fact, true that downloading has cost the record companies money, although not as much as they say it has, and that it might in the future cost the film companies money, although in my view it is not costing them a substantial amount just now, although they claim otherwise. And more broadly, just the idea of the internet in which reproduction is almost costless is clearly going to pose certain kinds of challenges for a system which was created on the idea that reproduction was actually relatively hard and that one actually had to make a fairly conscious decision and perhaps even invest capital and labor in order to engage in reproduction. The internet makes it hard to avoid reproduction. One generates copies all the time. The system's meaning is changed. A set of, if you want to think of a martial metaphor, landmines that were designed only to be triggered by the heavy rumbling treads of a tank can now easily be set off by the footsteps of an individual, perhaps even a 12-year-old. And as a result, even if the law remained perfectly constant, the meaning of the law has dramatically been changed. The debates that this vast body of scholarship deals with is largely focused on claims about the costs and benefits currently working online, with those who favor more expanded rights, stressing rightly that the internet has facilitated large-scale distribution which is unauthorized, which is piracy in the view of the intellectual property owners, and that as a result greater rights are needed. And so we need stronger rights, we need different kinds of protections, we need a different architecture for the internet, we need persistent IDs, we need what Pamela Samuelson calls texts that rat on you, books or music or films which, when they are used in an unauthorized way, phone home, tell the RIAA, help, I am being played by an unauthorized individual. Or perhaps simply register that you are playing them in an unlicensed way and demand payment from you, or perhaps simply shut down your computer. Are both technical, the proposed Microsoft Palladium system, and legal, the Digital Millennium Copyright Act, and the fusion of technical and legal, as in where either it is proposed that a new technical standard be mandatory, or that circumvention of it be either a tort or a crime, or perhaps both. The people who criticize this wave of new expansions has tended to focus on the corresponding benefits that the internet has brought. Don't assume that easy reproduction is just a cost, they say. Look at the benefits it brings, why you can distribute your stuff to the world. That's easy. You have a larger market. Your advertising costs are down to zero. Your distribution costs are down to zero. To be sure, the market is leakier, but it's also a lot larger. You may be losing a larger percentage, but you're also gaining a larger percentage. Before we rush off to invent new laws, might we not want to wait just a little bit to see what the actual effects are? The debate is largely inconclusive. It seems to me the minimalists have the better side of empiricism, logic, argument, constitutional history, and original purpose on their side. The maximalists have more money, power, and the ear of the powerful, but they also have some arguments that cannot be dismissed, and they are too frequently dismissed. I want to focus tonight on a completely different set of issues, though those ones are important. I want to focus on the intellectual property system, the copyright system, the default rules that it sets up. For those of you who aren't legal scholars, there's been a lot of very interesting scholarship by lawyers and lawyer economists recently on the role of law in setting up default rules. Default rules are the rules that you get if you don't do anything to specify otherwise. If your word processor were a legal system, the default rule would be Times Roman 12 point single spaced, right? That's what you get if you don't do anything. You can change it, but that's what you get if you do nothing. One very important role of the legal system, often understudied, is in setting up the default rules. What applies in a contract if you don't specify otherwise? Where is the appropriate place for it to be, for the contract to be decided in the law which applies to it if you don't decide otherwise? How will we deal with damages if you don't decide otherwise? Where did the rights start unless you say otherwise? Default rules are extremely important. They're important because frequently people won't do anything. They're important because they may well be sticky. If we set the default rule in a particular place and give you the right or don't give you the right, it may actually be not quite as easy as the economists think for us to change the system. And they're important because they provide the baseline from which we move. Okay, so setting the default rule right is very, very important. Okay, I want to focus on two default rules in copyright online. The first default rule is you don't get copyright unless you ask for it, unless you actually specify you want one. And the second default rule is your copyright expires unless you renew it. Those are two old default rules that we used to have with copyright. Now, it used to be that those of you who are assiduously taking notes would not get a copyright in those notes unless you wrote copyright at the top. Copyright Robert Cohan, 2003, little c in the circle. And with varying degrees of formality prescribed, basically not much more than that. By saying that, you got the copyright. To be sure, to sue, you'd have to do something else to go and register it. But you got the copyright at the point that you wrote down copyright. And by saying this, you expressed your desire to have a copyright. You said, I want to lock this up. Maybe I want to sell it. Maybe I just don't want you quoting it. Maybe I'm just a kid who likes writing copyright at the top of everything I write. But for whatever reason, I'm asserting that I want it. This was, of course, it's very similar to patent. We don't, for example, just give patents to people without them asking for it. In those of you who are patent scholars, just imagine if you could go around and every time you invented something which was novel, non-obvious, and useful, ka-ching, automatically a patent came into view without anyone else knowing it, or even frequently you knowing it. Because my guess is that most of you who are not legally trained, and probably many of you who are legally trained, did not realize that everything you have produced, that you've fixated, every picture you have ever taken, every song that you have sung into your tape recorder, the things that you have typed in your term paper are all copyrighted when you wrote them down, regardless of whether you wanted it or not, from the moment that the fixation of the mechanical rather than the Ingmar Bergman type actually occurred, okay? So you didn't get copyright unless you asked for it, and what's more, after a period, 28 years perhaps, the copyright would actually expire unless you wanted to renew it. We know that the vast majority of works, estimates range from 92 to 97%, lose any commercial value after about 5 years. Okay, after 28 years, if you didn't say, I want to continue this, you didn't need to pay anything, just say, I want to continue this, your copyright would expire in the case of a published work, and the work would fall into the public domain. Those were really good default rules, in my view. They weren't particularly onerous. Writing copyright is not incredibly onerous. Most people can manage it, right? Given that we're giving you a monopoly that now may well last for 120 years, life plus 70, right? Perhaps even longer for the youthful among you, and that it is a felony in many cases to violate this monopoly, it doesn't strike me as amazingly burdensome for you to actually say, oh, I want it, by writing a single 9-letter word, right? And it just doesn't strike me as an incredible burden. The idea that we let work fall into the public domain if people didn't insist that they wanted to keep it under copyright also seems to me eminently sensible. Those who wish to keep their copyright may indeed maintain it. Those who do not care, who are dead and have forgotten to tell their heirs, who are no longer exploiting their work, the people who were the copyright holders and are now forgotten, we can't even find them, the owners of all of the films and books and poems and pictures that sit in our archives, completely uncommercially produced, just sitting there rotting away, the acetate turning to dust, the paper turning to dust, would actually fall out of copyright into the public domain. Again, Not if you wanted to keep it. J.K. Rowling could extend her copyright, and that would be great, and Harry Potter would be copyrighted until the year dot. But if you didn't want to, or at least if you didn't assert it, then it fell into the public domain. Again, a great default rule. This is what happens if you don't do anything. We changed those rules, however. Starting in the mid-1970s, so the set of rules that came into effect in the mid-1980s, we did exactly the opposite. Now you get copyright unless you expressly disclaim it. And in a moment, I'll point out that it's not terribly easy expressly to disclaim it. Whenever you write something down, everything is fixed the moment you write it down, regardless of whether you put the copyright symbol or not. And it lasts for whatever period Congress gives you. And there, again, you need not just merely not to renew, but you need to go out and specifically say, I'm now giving up my copyright and putting it into the public domain. And again, that turns out to be a little harder than one might imagine. So when those rules came into effect, let's focus on the mid-1980s because that's when they really largely came into effect, which is pre-World Wide Web, they're not pre-internet. Those rules obviously have some costs. The rule saying that everything was copyrighted the moment it was written down, that had costs, but they weren't too bad. All of your notes were now copyrighted in your books. But basically, who cares? Right? I mean, so what? Your notes were now copyrighted. I couldn't get access to them anyway. They were just your notes. Your shopping list, if it had that element of creativity, which the Constitution and the copyright law requires, and I've seen some shopping lists which do, would now be copyrighted. But again, who cares? I mean, in practice, this had little effect. To be sure, it might come up when someone discovered that a diary or some letters were copyrighted when previously they had not been, but even there, the difference wasn't that great because there'd always been slightly different rules about unpublished works. So there was an effect, but the effect was not as great as one might imagine. The rules about expiration did have an effect. But even there, the effect was limited. Now, all the works which previously had fallen into the public domain and been available for commercial producers of alternative editions, let's say. So Dover Press wants to produce its low-cost versions of the classics. The stuff falls into the public domain. Great, now I can now do it. I can produce an adaptation, a children's version of Moby Dick, a large print version, an illustrated version. Those of you, by the way, who are interested in the creative power of the public domain should go to Amazon.com, take a contemporary classic still under copyright, Catcher in the Rye, say, and then take one which is out of copyright, say Moby Dick, and look at the number of works that are listed under each. You'll find a couple, 3, under the one under copyright. You'll find 20 or 30 versions, the one out of copyright, because now we can make the adaptation, the version in verse, the version in large print, the illustrated version, the VCR version, and so forth. So there was a cost there, a real cost, but it was largely a cost to the group of people who existed in the publishing industry to take public domain works and make them more available. It was a cost to archivists. It didn't really affect many of you directly. You might realize that it was curious that you had to pay such high prices for books that had been written a long time ago. If you thought about it or thought about it at all, it probably didn't affect you that much. Now, add the World Wide Web, and things suddenly change. One has a dramatic irony. Let's say that in the mid-80s we changed the rule about actually requiring people to specify that they want a copyright. And let's say by the mid-90s we have a functional World Wide Web. Suddenly, all of those diaries, those little sheets that you wrote up to hand out to your calculus class to illustrate how to teach calculus, those really cool pictures you took of the Empire State Building that were sitting in the bottom of your sock drawer, those poems that you thought were interesting, that little guitar track you'd laid down, the way you'd played around with that old Beethoven tune and rearranged it, all of those things which had sat in sort of some dusty sock drawer now could be, and in many cases were, put up on the World Wide Web, and generally put up without any indication of their copyright status. Suddenly, when you went onto Google to find out something about how to raise beagles, or how to teach your class about a supply and demand curve, or how to turn off cell phones, you would find yourself confronted with a vast morass of information, which was very nice. And in almost all cases, the legal status of that information would be unclear. You might say, well, of course, it doesn't matter. The person had put it up on the internet. I can use it. Well, you certainly can read it. I'm almost certain of that. Reading it is legal. Interestingly, you might think, well, if you put up on the internet, I could, for example, have a search engine which displayed thumbnail pictures of the images that you have up on your site so that someone could use an image search engine to find images. That might be legal, it might be fair use, but it also might, in a curious way, violate Copyright Act, so you better not do that. You might say, well, I want to distribute to my class, or maybe put on my web site, or maybe just create a derivative version of this wonderful interactive Java applet here, which shows, demonstrates some of the something about an integral, or that can be used to teach someone calculus or the quadratic equation. And you go to your administrator or your local school board or the person who does the photocopying, and they say, not so quick. Who owns the copyright to this? Well, I don't know. It was on a site. There was a link to something else, and the web page was down, and I tried to use his email address, and that didn't work. But I'm sure he wouldn't mind. And maybe they'll let you, and maybe they won't. Most likely, they won't. At this point, I have to tell the story of this. Of course, predates the internet. When I was at Boston University, I wanted to use one of my own articles in a torts class, which some of the students here, poor things, have actually been forced to read. And I took it to the photocopier, and he said, I'm sorry, we can't reproduce this. You're photocopying the whole article, that's more than fair use, which I happen not to agree with, but let's put that aside. And I said, yes, but I wrote it. He said, yes, I know, but you don't have permission. I was like, okay, I grant permission. He said, you don't have written permission. I grant permission to James Boyle to photocopy this article, and hand it to him. And he said, well, I'm not a lawyer, but even I know this isn't typed. In similar vein, I'm writing a book now in which I quote from a poem probably written in the mid-18th century about privatizing the common, locking up the common. In the course of doing this book, I wanted to find out this wonderful poem. The law locks up the man or woman who steals the goose from off the common, but lets the greater villain loose who steals the common from under the goose. Great poem, I thought. Well, where does it come from? Well, it turns out it's very hard to figure out where it comes from. Anon is probably the author, as she is the author of so many things, but when did Anon write it? Very hard to nail it down. There are 25 different attributions on the internet, all of them speculative, and I'm sure at least 24 of them wrong, and I attempt to track down through the coerced labor of a research assistant which one of them is correct. My research assistant sends a nice letter an email saying, we noticed that you cite this poem and you give the following attribution for it. It was by Piers Plowman, it was 1860, whatever. Can you tell us what your source is for this? Of the 25, he got back 17 apologetic emails which said, we're very sorry, we'll take it down immediately, please don't sue us. A North Carolina newspaper promised, quote, the reporter in question will be disciplined. So I don't know if the RIAA is changing perceptions of downloaders, but there's certainly a message out there that pretty much everything is owned and you can't use it, and if you do, you will be sued. When we sent back a letter, go, no, we just wanted to know where you got it. It's like, we got back other things. Really, please, it's down, don't take the house. In any event, so what happened with the World Wide Web is that suddenly all of this material automatically and immediately copyrighted, whose actual authors and owners had widely varying intentions for it. Some of them might want everyone to use it for any purpose. Some of them just might want their name attached to it. Some of them might be perfectly happy at any non-commercial use, but not want it commercialized. Some of them might want it to be free for ripping, mixing, and burning, for derivative works to be made out of it. Might love if someone sampled their song. Somebody else might hate the thought of their beautiful digital video being carved up by some heathen and want to make sure that it stayed exactly as it was. The point is that the default rule they got was one that said all rights reserved. And that's all they got. And what's more, since they largely weren't aware of what their rights were, and weren't aware that they'd actually frequently copyrighted the stuff they've created, they either didn't or couldn't express their intentions about use, and even if they could express them, it wasn't clear that those intentions were in any way legally binding. A group of us who thought that this was a problem, and I'll come back to the other problem, the problem of term limits later, went to the Copyright Office and said, we want to make it easy for people to dedicate their works to the public domain, for them to put it into the public domain. We want a simple form of words which you will agree and which you'll actually put up on your website, where you say, this is how you put something in the public domain. Those are the people who want none of the rights. Now, that may not be ideal, because you might actually want some rights, right? You might want attribution. This was written by, Bob Cook Deegan. You might want these other. Ideally, you'd want a more fine-grained, a more granular thing where you could give some kinds of access and not give others. So it wasn't ideal, but at least there were some people who wanted to truly give it all away. So we asked the Copyright Office, how do you do this? And the Copyright Office said, and I quote, we don't provide that service. Get creative. And this point of view is not unusual. By the way, come on down. There's seats down the front. Don't feel that you have to sit up there where it's uncomfortable. There's some over there. Come on, there's plenty. Let me quote from an official of the US Patent and Trademark Office. It had been proposed that a meeting be held under the auspices of WIPO, the World Intellectual Property Organization, to deal with various kinds of so-called distributed or open source production. Open source software is the best known example. Types of production which rely on intellectual property. It's not public domain software. It's in fact copyrighted, but is subject to a license which says if you want to change this stuff, you have to put your code under the same terms of the license under which you got the stuff that you're changing, so that it is available to others, they can see the source, and they too can change it. It's a kind of ever-expanding commons. Your price for playing in it is that you agree to add your innovations to it. IBM has recently started an advertising campaign upon these themes, saying, if Linux were a person, he'd work for everyone. I don't know if that quite expresses the idea, but the notion is of a commons built on intellectual property rights. It's the rights that actually allow people to enforce the contract which guarantees that the stuff gets expanded. And there are many other kinds of such production. These are actually quite interesting and useful, commercial sometimes, types of production, and it was thought that WIPO ought to actually look at them and see how it could deal with them. They were going to have a meeting about it. There were complaints for a number of companies, including Microsoft. And immediately, the US Patent and Trademark Office started complaining to WIPO. This is what Lois Boland, Director of International Relations for the Patent and Trademark Office, said. Open source software runs counter to the mission of WIPO, which is to promote intellectual property rights. To hold a meeting which has as its purpose to disclaim or waive such rights is contrary to the goals of WIPO. Now, this is a really interesting idea about property rights. Presumably, it means that if we think of some other kind of property, like let's say my property over my watch, it's okay for me to have it, but if I ever wanted to give it to you or sell it to you or exchange it to you in return for a service, that would somehow be bad for property. This is not what we normally think. We don't think that there's a requirement that property A only be closed and B, that it stay with someone. In fact, that system isn't property at all. It's status. It's feudalism, right? The idea of a market economy is that we have lots of property rights that we can exchange in different, interesting ways with lots of other people in the creative mix we most need. This doesn't promote property rights. On the contrary, it's the very essence of property rights. What they're saying is we only like one business model about using property rights, but that's something very different, okay? So, as I said at the beginning, while I can produce a wonderful, and I gave you, I'm sure, not a wonderful, but at least a comprehensible academic critique of the current default rules we have about intellectual property, that this lock it up unless you say otherwise, it's quite hard to say otherwise, leaving all this material on the World Wide Web, while potentially available to you, leaving you very unsure how you can use it. Can you use this fragment of digital video in your film? Will you be sued if you do? Will your distributor say, where did you get permission? Will you be able to use this classroom module? Can you add to it? This, after all, is what the World Wide Web is supposed to allow. Copyright, which is supposed to aid innovation, is here standing in its way. What's the solution? The best solution, which is impossible for two reasons, is go back to the old rule. We have to say copyright. It's a pretty simple rule. It's hard because Congress doesn't listen to proposals like that right now, and it would in any case be a violation of the World Intellectual Property, the WIPO Treaty, which we have signed. So for a couple of reasons, that's not possible. So now we come to the second best solution. Could we get the Creative Commons website, please, Wayne? So this is the practical component, trying to make good on the default rules critique. What we wanted to do is to, this is a group of us led by Larry Lessig with a number of people from the computer science and creative communities. What we wanted to do, if you could bring down the lights a little bit, that would be great. What we wanted to do is to set up a system which would actually allow people to express in the fine-grained way that we have been talking about the specific intentions that they had with regard to their work. The first thing is simply for them to be able to say it so that a lawyer could understand it and apply it, and that a court would enforce it. And that is in itself not incredibly easy. You have to be very careful about the way you write the license. The second thing, though, is to express it in the way that a human being, the development office wouldn't let me suggest that human beings and lawyers were separate classes in the publicity for this, but I feel I can suggest it to you, that an ordinary person unburdened by legal education could understand what it meant, because the point here, of course, was that while the older system of copyright largely dealt with industrial repeat players who had well-defined desires and knew exactly how to copyright their stuff and what they needed, the new generation of producers who are affected by copyright do not have high-powered law firms, do not understand copyright law, and need to have it explained in terms of the projects that they're engaging in, rather than in a legal document which may be somewhat hard to understand. And finally, ideally, to use the genius of the World Wide Web, in particular the idea of the semantic web, to express these desires not merely in legal language or in human comprehensible language, but in machine comprehensible language, so that you could, ideally one day we hope, go into Google and say, show me all digital videos of the Paris skyline that are available for non-commercial use with attribution. Show me all teaching materials on calculus that can be used in the following way. Okay, so I will attempt to use the wireless mouse and see if we can do this. Okay, so what we need to do here is choose a license. So here you see, let me turn this on as I come out. With Creative Commons, you can go through, do you want to require attribution for your work? Do you want people to have to say that you are the author of this work? Do you want to allow commercial use of your work? Maybe no. Do you want to allow modifications of your work? In other words, allow people to cut it, to take an excerpt from it, to sample from it if it's a song, to take a fraction of your poem, or perhaps even to transform it in different kinds of ways. You could say yes, you could say no, or you could say, yes, I don't mind so long as whatever they make is covered by a license that is at least as generous, rather like open source. So you could then also select the format of your work. What are you looking at here? Is it audio, video? Let's say it's... And then you go to select a license. Congratulations, you have selected the Creative Commons Attribution Non-Commercial Share-alike license. Here is the human-readable Commons deed. You're free to copy, distribute, display, and perform the work to make derivative works. See, it was very important to get icons that represented the different ideas, because people don't have time even to read this much. Non-commercial share-alike. Okay. And there's the legal code and the machine-readable digital code, which expresses through the wonders of metadata and RDF the same idea, so that this can be tagged, put on your website, and people can actually be able to find it. Okay. Let us go back to the... So, Wayne, can you bring up the flash? Or do I just do it here? Okay. The other thing we had to do is actually explain it so that people would understand what we were doing. So this is the attempt to reduce everything I've just said to you to cartoon form.
These are Jack and Meg White, also known as the White Stripes. They're a band from Detroit. They make rock and roll without a bass guitarist. This is Steve McDonald of the veteran band Red Cross. Steve thought White Stripes could use a bass player, so he appointed himself. He took the White Stripes' latest album, called White Blood Cells and re-recorded it, laying a bass track down on every song. Then he released the results as MP3s on Red Cross's website. He even made up a new album cover and title, Red Blood Cells. McDonald began putting these copyrighted songs online without permission from the White Stripes or their record label. During the project, he bumped into Jack White, who gave him spoken assent to continue. It can be that easy when you skip the intermediaries. Collaboration across space and time. Creative co-authorship with people you've never met. Standing on the shoulders of your peers. It's what the internet is all about. It can be that easy when you skip the intermediaries. But couldn't it be easier still? Not very many of us are liable to just bump into Jack White and get the green light. Isn't there an easier way for him to invite you and me to pick up a bass as well? Shouldn't we be able to if he doesn't mind? Shouldn't it be easier still? Enter one of the Internet's most famous citizens. A face familiar the world over, a public identity rivaled only by a handful of corporate giants and global superstars, the big copyright C. Everyone knows what Big C stands for. Big C means all rights reserved. Big C means ask permission. Big C protects copyright owners and notifies the rest of us of their ownership. The time was when you had to put Big C on anything you wanted to copyright, or else it entered the public domain, the commons of information where nothing is owned and all is permitted. You had to put the world on notice to warn them. That was Big C's job, and it was a useful one. What changed? The law. By the late 1980s, U.S. law had changed so that works become copyrighted automatically the moment they're made. The moment you hit save on that research paper, the second the shutter snaps closed, the instant you lift your pen from that cocktail napkin doodle, your creation is copyrighted, whether Big C makes a cameo or not. So suddenly, there's no quick way of knowing whether something's owned or not. The new rules may be clear about how you get to own a work. You don't have to do anything, but they say nothing at all about how you should go about announcing that you want to allow certain uses of your work. So what? Well, if you're a digital filmmaker whose every frame must be cleared by an army of lawyers before making the cut, or if you're in a band whose label won't let you put a song on a file-sharing network, or if you're a professor trying to put together online course materials, or if you're a DJ chasing down permission to use every snippet of song in your sonic collage, if you're one of these people, then you know, so what? We interrupt this brainstorm to call the lawyers. You drop what you're doing and call all the lawyers. You ask for permission, even to use a word whose author doesn't mind if you use it, because you have no idea what the author's intent is. You ask for permission, even to share some of your rights. Or you venture forward unsure what your risks and rights are exactly. Or, in a haze of legal doubt, you do nothing. Bottom line, Big C is out of a job. The middlemen are not. Enter Creative Commons. Creative Commons wanted to find an easy way to help people tell the world up front that they want to allow some uses of their work. We called the experts, the U.S. Copyright Office, for advice. Their response? There's no real answer. Get creative. So we got creative. How? Our CC brand marks works that are governed by Creative Commons licenses. A set of standardized copyright licenses available free of charge on our website. We wrote these licenses so that lawyers and courts could read them. Then we translated them into a language you can read. And then we translated them into a language computers can read. Now, CC isn't meant to compete with copyright, but to complement it. It allows you to retain your copyright while granting the world permission to make certain uses of it upon certain conditions. If the big C is like a red light, then CC is a green light. If the big C says no trespassing, the double C says please come in. If the big C says all rights reserved, CC says some rights reserved. Even no rights reserved. So you can use the powers of the net to find works for you to share and build upon, and to invite other people to transform or trade yours so that you can get creative, not only with what you make, but how you make it available, so you can collaborate across space and time, so you can be a co-author with someone you've never met, so you can stand on the shoulders of your peers, all without asking permission, because permission has already been granted. Creative Commons.
Thanks.
Get creative. It's easy.
So there's actually a reason why I showed you all of this, apart from just I love the fact that we actually encapsulated a legal argument in cartoon form. It turned out to be a lot harder than you might think. The first thing is that I started at the beginning by suggesting that our current debate about the internet focused on losses that are easy to see, losses that we hear a great deal about, losses to Britney Spears, losses to commercial products. Those are real losses. What I was trying to suggest is that we are blind to another kind of loss, the loss that is caused by bad default rules, the loss that means that we lock up 97% of the books in the Library of Congress in order to preserve the 3% that are still being economically exploited when we could have digital access to all of them. The loss that is created when we make it harder for people to share their material with each other, to co-author, to actually build on each other's work. So the first thing was to try and get that point across, that there are actually other forms of losses that you're hearing about that are not captured in the rhetoric of piracy, that actually have to do with the operation of the copyright system. The second thing, and perhaps the more successful thing, was to try and create something which, as I suggested at the beginning of the lecture, actually changed the way that people thought. So that certain people would confront this and go, really? That's the way the law is? I have to do that? That's so, that just the act of doing it, of putting up the little logo, itself is something which changes people's minds. So what's the effect been? Well, it turns out to be harder to figure out exactly how many people are using our licenses than you might suspect. I could bore you with all the details of how Google actually does web pages. But using alternative methods, it seems that between 750,000 and 1 million people are currently using our licenses. What's the biggest market? It's basically hobbyists, bloggers, academics, and people in the sort of transformative music and film worlds right now. We're getting more and more interest from educators and actually from various kinds of online publishers who prefer using this. We have some fascinating adoptions. MIT has decided through its open courseware project to put every single course that is taught at MIT online. And when I say online, I mean all of the lectures together with all of the teaching materials, frequently video of the actual lectures, so that if you're a kid in Nigeria with an internet connection, you can actually take a computer science class from an MIT professor. You don't get an MIT degree, but you do get an MIT class from an MIT professor. It's all available free. All of those, MIT is putting something like $40 million in, they are releasing all of those under our licenses, under Creative Commons licenses. That was clearly fabulous. We are working with the BBC to see if we can get the BBC to release all of its archives under our licenses. So there are the sort of, the great content, from the great institutions, universities, et cetera. And that's one focus which we're pursuing. To be honest, though, I think that the larger effect of Creative Commons may be in transforming attitudes. What we've found is that people apply Creative Commons licenses, and though we very carefully and really positioned ourselves as completely neutral on the copyright issue. At our launch, we had a video endorsement from Jack Valenti, in which he pointed out that this was, after all, about authors asserting what they wanted done with their own work. It's a property rights issue. Jack Valenti saw it, even if the PTO does not. You're the author. It's your copyright. If you want to let someone use it, it's up to you. We also had John Perry Barlow, whose views are rather different, former lyricist from the Grateful Dead, and he too endorsed us. And we took the position that we're basically neutral as to what the right model in the copyright system is, but clearly everyone loses if people are having stuff locked up when they actually want people to be using it, and everyone could accept that. Interestingly, despite that mode, which is kind of the land trust mode, the idea of the conservancy, where everyone can agree that it might be good to dedicate this land to a conservancy, doesn't necessarily take a position as if you were Greenpeace or, for that matter, Earth First. Despite that fact, it's turned out that Creative Commons has had a huge amount of impact, I think, actually in affecting the debate. And people frequently say, I take a Creative Commons view on this, by which they actually mean something closer to my initial position here, namely that we should change some of the rules of copyright to acknowledge the realities of the net and deal with the fact that a set of rules designed to engage in horizontal industry regulation among repeat players who were only worried about direct competitors is now affecting everyday users who are the citizen publishers of cyberspace, and that we actually need to think about what kinds of rules we want to apply there, particularly to think about their free speech and creative effects. So that's the idea of Creative Commons. It was actually fascinating as an academic having to turn some of your ideas into something that actually worked. I don't know if I'd ever want to do it again, but it was actually fascinating. It was akin to setting up a company. It turned out there were enormous numbers of legal problems, ranging from why weren't we engaging in the unauthorized practice of law. There were enormous numbers of problems dealing with touchy other issues. Was this a competitor with the general public license? Was this an attack on the free software movement? Answer, no. There were all kinds of technical issues, which were fascinating and largely incomprehensible to me. There's really interesting issues about how this would apply internationally. We're actually we're working with people in lots of other countries around the world to try and translate the Creative Commons licenses into their particular language. But what also seems to have come out of it is a relatively robust set of connections in civil society of people who are now being made aware that the legal contract that was signed by the people who set up the copyright system they have does not necessarily serve their needs. And so I'd suggest there are a couple of takeaway points here that actually might be of interest in scholarly terms. The first thing was that, as I suggested, we shouldn't focus merely on state bodies when we engage in advocacy. Often the most effective form of advocacy can be a demonstration project. Here, I do this, and you can see that it actually changes something that is worthwhile, and that can be done with a private audience rather than an audience of state decision makers. The second thing is that the same technologies which create, in one sense, the problem, the technologies of the internet, can also be harnessed to try and solve it. To be sure, Creative Commons is a massively second-best solution. The best solution would be putting the default rules back to what they are. But nevertheless, it's I think, a useful one. And the third thing is that we need to, when we are engaging as public intellectuals and law reformers, not merely to make an abstract argument or even to write an op-ed which says this is, what's wrong, but actually trying to construct something which embodies the principles which we think that are right, to offer it to people as more than just a criticism. The trouble with much of what's gone on from people who hold the views I do on the way in which intellectual property policy has gone wrong over the last 15 years is that we have been reduced merely to the role of naysayer. A new dreadful bill comes up in Congress and we say, it's awful, the sky is falling. After a while, though it's true, the sky is in fact falling, that gets old. And this, I think, is a very different approach and a potentially valuable one. So, thank you very much, and I'll take questions.
Two sub-questions. Is copyright law in other advanced capitalist countries like ours, or is this a distinctive American phenomenon? And secondly, is there a process of diffusion or imitation that goes on that is traditionally have other countries imitated U.S. or other copyright law? And if so, is there an imitation process that you can take advantage of that imitating you on the creative?
Great questions. Copyright laws are becoming more and more similar, largely under the force of the trade-related aspects of intellectual property, where they're literally mandated in certain regards, but also a process that began long before then, the WIPO process, has attempted to harmonize copyright laws worldwide, although, as I like to say, this kind of harmony is one that only goes upward, like a barbershop quartet that only went to the soprano range. You know, harmonization, in the view of those who want to harmonize, turns out to be only in terms of increasing rights. In some cases, US law was more permissive than the European ones. For example, the rules that I describe here, and I had a whole section which I cut in the interest of time, the rules that I describe here, dispensing with formalities, were largely driven, although not entirely driven, by a set of European concerns which a distinct European sort of legal ideology saw formalities, such as having to say copyright, as archaic, old-fashioned. Modernity meant we would have a streamlined process of creation. And they finally introduced that rule just in time to meet a communications technology which would make it have the absolute maximum worst effect. It is still very hard to talk to the Europeans about this because they persist in seeing the concerns that I've been raising here as somehow formalistic and archaic, and you really have, I think, a distinct legal ideology very different from the commercial interests that also sometimes drive these things. Note, by the way, that many of the rules I'm describing here would have zero impact on commercial interests, who easily and trivially could simply put copyright on their stuff or renew their stuff. It's more the ideological effect that they're worrying about. This is chipping away at something that they want people to think of as an absolute property right, like I own my house, rather than a limited and temporary government grant given for specific purposes and only if you jump through certain hoops. So it's more an ideological concern, and it has its own relatively autonomous legal ideology going along. So we were, in this case, copying the Europeans. In terms of the process of diffusion, again, partly because of TRIPS, but also through WIPO, there is a process of diffusion. Unfortunately, it's diffusion, from my point of view, that's going in exactly the wrong direction. Since everyone loved the Digital Millennium Copyright Act so much, we are attempting to export even more toxic versions of it worldwide, many of them without even some of the limitations that exist in US law. Similarly, since the Europeans have done so very well with their database law, which locks up facts, we've decided to introduce just such a bill in Congress so that we too could reach that happy state. So yes, there's the process of harmonization, but it only goes up. However, there is a process of diffusion in the way that you describe, and people have been quite interested in this, the Creative Commons sort of seen as a moment of resistance to this, which, to be honest, though, of course, that was what motivated a lot of the people who started it, we were quite surprised because there are all these other organizations out there, the Electronic Frontier Foundation, the Public Knowledge, and so forth, who take overt stances against the expansion of intellectual property. Creative Commons, interestingly, despite the fact that formally speaking it was neutral on this issue, is invoked far, far more often as by lay people as representing this. And I think the idea is beginning to percolate. I do have an optimistic hope here, which is these rules are actually, I think, becoming a pain to ordinary users. And I'm not just talking about the downloading stuff. To be honest, heresy though it is, I actually think that probably downloading 1,000 songs from total strangers is something that intellectual property does, as currently constituted, forbid. I call me a radical. But I think more people are, it used to be that people really didn't know anything about intellectual property. They certainly didn't want to talk about intellectual property. And they didn't deal with it on a daily basis. I think the fact that they have to, and that they see its effect on what they can do and what they can't do, actually is the single most positive force here. Because I think we're actually getting people sort of irritated by this, and people wanting a simpler system. Jessica Littman, who I mentioned at the beginning, once said, if the public were your client and the copyright law were a contract that he or she had to sign, and you were the lawyer, would you have them sign it? And when you look at it that way, the answer would be no. She proposed a 3-page copyright law, which basically would codify what most of the people in here wrongly assume to be the law. Yeah, I can't engage in direct competitive use, et cetera, as being infinitely superior on all kinds of grounds. And I think things like Creative Commons are moving in that direction. That's a different process of diffusion, though. Other questions?
Do you think that the Creative Commons drew a lot of heat, because ideological heat at least, because it seems to be
Well, that was the interesting thing. A lot of people say that, say the public domain, and we hasten to add, actually, of course, this work isn't going into the public domain. Although public domain is one of the options there, it's actually one of the least used options. Interestingly, the most used options turn out to be non-commercial with attribution, right? Which doesn't surprise one at all, although there's a very substantial group that want to allow derivative works and sort of take the open source approach. So it's, so I think people were attracted to it. I don't think they drew very precise distinctions, and to be honest, not many legal scholars do either, between the public domain, no rights whatsoever, and some notion of commons where we're trying to build a space in which you can do certain things but not others. Even on the grassy commons of Old England, you couldn't come in and just, dig everything up and take it away, cut down the trees. You could perhaps graze your cows and so forth. There were limited rights and responsibilities. This is a similarly sort of correlative notion. This is more of a commons than it is the public domain, although I think people use those terms interchangeably. To be honest, scholars are just as bad as lay people on that front. Yes?
Is there a way to research a listing of by category of items that do have this Creative Commons?
Not as well as we would like. We've been working with Google and all the web and a variety of other web search engines. Our initial sense was we'd put it all on our website. That was the kind of, Stalinist centralized notion, which we realized was completely contrary to the spirit of the whole thing. This was a distributed system, let people label their own content on their own sites. So then we thought, well, we'll label it, we'll put the flag up, and the search engines can find it. And that, for me, was one of the most exciting ideas. Turns out that there are difficulties in that, all kinds of fascinating difficulties, like how do you put the metadata inside PDF files or MP3 files? So we're actually pretty close to the MP3 one. We think we've pretty much cracked. The PDFs, we're working with Adobe on that. So we're trying to solve all of those problems, but there are enormous technical problems. What's more, the search engines themselves will be kind of, well, maybe we'll get into this, maybe we won't. Not clear that they want to engage in it. So right now, you can do it. We've run up sort of demo apps that allow you to do it, but it doesn't have the precision that we want. I think this is one of the most exciting ideas about Creative Commons. I have to say, I'd give it at best a 50-50 chance of ever really being pulled off in the real world. And at first I thought if it wasn't pulled off, it would be a complete failure. That if we couldn't do this, the idea of the commons that we were building would just be a disaster. Interestingly, it has turned out that Creative Commons as idea is probably at least and maybe more important than Creative Commons as searchable context. What people tend to do instead is go to look for a specific thing, and then when they get there say, it's covered by a Creative Commons license, I can use it, rather than doing the kind of search that I described where you start with the legal category as one of your search terms. Final note on that, we're also trying to expand Creative Commons to deal with science, because while not all of the techniques and skills that we've developed apply to the world of science, some of them may well do. In that context, the machine-readable quality of the licenses might actually be something which it was much easier to implement. So you could know, you could make data available, and you could make it available under more generous terms, and people could know what those terms were in a machine-mediated way. It might actually be easier to do that in the science world than in the culture world. So the answer right now is we're working on it, and we're at best only partly there. Bob?
If somebody dies and there are heirs now, they change their mind about how they want
Yes.
copyright the work. How does that work in this scheme?
Well, assuming that our licenses are enforceable, and I happen to believe they are, then the answer is that they could withdraw the permission as to the future, but not as to the past. So if you had used the work in one of the accepted ways under the initial license, you're totally fine. And depending on what the license, you may even have a continuing ability to do that on into the future. However, there is a question, if they cut it off, other people may not be able to do so in the future. There's a fascinating question also about reversionary rights and rescission rights and whether or not these rights cut off under copyright, which we spent a vast amount of legal talent solving. But I think that's broadly speaking the answer. Yes?
The licenses work great if the creator chooses to exercise his or her right directly. What about what do publishers think about this?
Publishers have, well,
Especially the scholarly community.
yes. Well, that's a very interesting question. Personally, what I want is for more scholars to be using these licenses, and actually, for the licenses, while they don't require anything in terms of the contract you make with the publisher, if more and more people start putting their stuff up under these kinds of licenses on their own website and start saying, I assume that I'm going to be able to do this for the preprint version of my article, that doesn't require Reed Elsevier to do anything, okay? But it may nevertheless have an impact if there is a large enough body of people. Some publishers, interestingly, are actually quite positive. A number of computer publishers have actually decided to adopt Creative Commons licenses. And one of our other projects, which deals more with the term limits point, which was the other default rule I talk about, is so-called founder's copyright. Founder's copyright is you say, I want 14 years. That's all the framers of the US Constitution thought I need, and that's all I think I need. After 14 years, my stuff's in the public domain. I think a lot of scholars would love that, would actually think that that was a perfectly fine deal. Actually, a large number of authors do. So, and that's had fair success. Finally, some novelists have been able to persuade their publishers to allow online distribution using Creative Commons licenses. Cory Doctorow did that, and his publisher was very wary, but he did that, and he got 100,000 readers in the first, 100,000 downloads in the first 6 months, and the book has now sold out 3 or 4 printings, and they've given him a contract for 2 or 3 new novels, and it does appear in that sense that the idea that giving away stuff under the Creative Commons license is a perfectly good way of building market share. If that's true, one could rationally expect, particularly for things like reading online, which is kind of a pain, but people would much rather have the book, particularly if the book is cheap. It's not necessarily a substitute good at all. Nevertheless, we've had far too little of it because people go, oh my God, if I make it available, what does that mean? It's available for everyone. It seems to me the licenses could be a very rational profit-making tool that publishers would want to use. Expect similarly an interesting announcement from Amazon.com along those lines. I may not reveal exactly what it will be since I am bound by a non-disclosure agreement, but there's more in the works in terms of usage of it by commercial entities.
If copyright or if all rights reserved has become the default, what about works created in official capacity, such as, for example, judicial opinions?
Great question. Federal documents cannot be copyrighted. Documents produced directly by the federal government, although if it's a work for hire, there's a set of other issues. State officially produced things are under a much more unclear legal regime, and there have been cases where states have claimed that their laws indeed were copyrighted, and at least in one case, there's some wonderful cases involving building codes which were originally written by private parties and then adopted by the legislature, where the people who actually wrote the code, which is now the law in X state, say, you may not quote the law without paying us or reproduce it. And people say, well, no, that's ridiculous. You can't do that. They got many courts to agree with them, although the most recent decision, thank goodness, is slightly more rational. So in Europe, the mode is entirely the opposite. Copyright has been, crown copyright in Britain, for example, is seen as a way for governments to raise revenue in scarce times. You find the same thing with weather data, where rights are asserted. And interestingly, by the way, some of the empirical evidence that we have on this indicates that that's a very bad choice, economically speaking. If you look at the tide services business in the weather industry, I'm sure all of you have been looking at a lot of weather sites recently, and you're aware that the government produces a whole lot of weather data and gives it away for free. And then there's a whole lot of other people who kind of massage it and add to it, and they release it, and they actually get paid quite a lot of money for it, whether it's the Weather Channel or Weather Underground or what have you. The size of the industry in the United States is approximately 12 to 14 times the size of the industry in Europe, and the information is far more widely available. One person who was trying to do comparative studies on weather in the US and Europe was trying to get all the historical data for 50 years so they could run various models to see whether or not their model was actually predictive. They asked for all 50 years of the US's weather, and I think they were charged $50 for about 12 DVDs, which contained all of those things. Then they went to Europe, they went to one place, one region in Germany quoted them the price of 8 million euros. Okay? So they just didn't include the European data in their modeling, so the American stuff is very relatively well modeled, and the European stuff is not. This is one of the wonderful things about information economics. Information is both an input and an output. If you commoditize it at the output level, the people upstream who would do useful things with it find they can't use it. And so you actually stultify the market. One of the things that the Creative Commons licenses might do, is to allow more rational, cold-hearted, profit-maximizing, value-added building on information, and perhaps change some of this, lock it up, that's the way to make money, because locking it up is not always the way to make money. Yes?
I just wanted to ask about enforcement. It seems like with either the public license or with Creative Commons, authors don't have a way to know who's violating their rights that they're claiming. And with the internet, it's so easy to violate those rights.
Right. The position that we took, our baseline is we wanted to put people in no worse position than they would have been in before, and where possible, better. Okay? So that was our goal. Obviously, people could have copied your stuff when you put a copyright symbol, or for that matter, didn't put a copyright symbol on it before. This does a number of things. First of all, it actually states your intentions. So for the people who are unknowing violators of your intentions, this should get some of them. So assuming there are some honest and law-abiding people on the internet, then by definition, you're a little bit better off, okay? Beyond that, the Creative Commons symbol, which is attached to the work, is itself something which you can simply search for. So you can obviously search for the use of your work. You can also search for this. There's also seems to be something of a community which helps to police it. Note, these licenses are held by the individuals, not by us. We are not the copyright holders. This is not like the Free Software Foundation. So what we do is we put you in this position, and then it's up to you to enforce the license. Will there be lots of people who can't afford to enforce it? Yes, absolutely. Of course, that's exactly the position they were in beforehand, and I hope they're a little bit better off. The other problem we've worried about is the reverse. I put up a song and say, here's a great, song, which is actually by Catch-22, which I happen to say is mine, and I put a Creative Commons license on it. And again, just as the copyright James Boyle gives you little guarantee, neither does CC with James Boyle's name on it give you much of a guarantee. We just work to try and stop that if we see it. But clearly, those are problems. I think the person is better off, though, than they were before. Back. Yeah, Justin.
So you said that before the WIPO meeting about open research and open source, various proprietary-based companies within the United States stepped in and said, that's kind of a bad idea. Why haven't we heard any news of companies like IBM or HP that have actually leveraged these technologies, kind of act as a counterbalance, to come back to the U.S. Patent and Trade Office and say, well, we make money off of this. We want to know how to make more money off of this.
I think they have, actually. I think it's not accidental that IBM launched that Linux campaign that I was talking about right after the discussion of the WIPO meeting. On the other hand, I think they're doing it much less publicly than I would wish. I really do think it's a very simple issue. The government should not be choosing between different business plans. It should not be picking winners. The government should be setting up a set of rules, and if people want to try an open source strategy or a closed source proprietary strategy, we should be neutral with regard to those. Now, some people say, no, we should be more positive with regard to the open source one, and maybe that my heart might lie there, but at least I could say we should be neutral, right? And that's, I think, what IBM and Red Hat and others have been saying, but they have been saying it largely in private to the PTO. Why? Because I think they want the PTO to go to bat for them in other cases when they are acting as themselves as proprietors. IBM holds a lot of patents. And may want the USPTO to do something. And this person at PTO is just so amazingly stupid. Really, it's just so stupid. But according to her logic, a patent pool, right, in which I agree not to sue you and you agree, is a violation of intellectual property's raison d'etre. It's so moronic that I think that anything that was seen as a disagreement would come down as a real sort of slap down. So. Those are the only reasons I can give. Well, we should have maybe one more, and then we can go to have our reception, and you can actually eat and drink. Yes?
Just wondering if you hear about any possible technical alternatives to the infrastructure of the web. And I'm thinking of way back to Ted Nelson and Xanadu.
Mm-hmm.
Are there any more thoughts along those lines, or any possible solutions to bringing property rights and micropayments and that sort of thing into the web?
Right. So in Ted Nelson's Xanadu idea, which was sort of the ultimate in hyperlinking, where everything was sort of connected to everything else through hyperlinks, which might also themselves contain digital payment systems so that you actually paid a fraction for your use or reference or something. That, by the way, was something that the USPTO clearly wanted. That was their image of what the World Wide Web would become, although in a rather darker way than Mr. Nelson imagined. Their vision was that every citation and quotation really ought to have, embedded micropayment electronically within it. The theory being that things like fair use had simply existed because of transaction costs that in the past had been too costly to seek permission, but now we could do it all electronically through automatic agents. And with the transaction cost argument gone, there was no other reason for fair use, not a conclusion that I personally shared. Creative Commons has a very distinct line on this, which most of the time we think is clear, although sometimes it does blur a little. We are in favor of digital rights expression. People saying, this is what I want you to do with my work. That's like a sign which says, take one, they're free. Okay? We are not in favor of digital rights management. That's like the box which, if you try and take a second newspaper, catches your hand. Okay? Every Creative Commons license becomes void if you try to use it with digital rights management technology. And the reason that we do that is Creative Commons licenses all explicitly say nothing in this license can affect in any way the fair use which you already have under US law or the laws of your jurisdiction, the fair use privileges that you have. There's no way that you can get more through the Creative Commons license than you have already. You can't take away fair use rights that others have. We were concerned that people would say, hey, we'll have the best of both worlds. We'll have a Creative Commons license, we'll put DRM in there, and we'll just wrap it all together, which would both blur our message, lose the important sort of iterative idea that I was talking about, the advocacy idea. It would lose us our audience, and it would also, I think, turn the whole thing into something that was its opposite. So as a result, we've stayed away from DRM. I think most of the micropayments ideals have, at least from my point of view, turned rather towards the dark side now. They are much more involved with creating what amounts to a mandatory architecture aimed at enforcing micropayments in which non-micropayments material would exist as a barely tolerated exception, okay? Rather than what I think we should have, which is a platform which is open to people if they want to embed digital rights management, steganography, watermarking, micropayments, even more power to them. And more power to them. And that was very good. That was really nicely done. Thanks, Kevin. Thank you. But I want the alternative to be there, and that's the line we've drawn. I think we should break and eat and drink. Thank you so much.